Okay, yeah, perfect. So we have started recording the webinar. Thank you all for participating. I can see more people accessing the webinar. Just so you know, the final Q&A will be managed through the Q&A chat. And indeed, the interventions of the speakers will be recorded, but not the final Q&A. So good afternoon. Welcome to the panel Illegal Occupation, Genocide and Business, Reflections on the Case of Palestine. This online workshop stems from spontaneous collaboration between today's speakers, whom I'm going to introduce in a minute, with the support of several organizations. So let me thank them. First of all, in no particular order, Al-Hag, SOMO, the Transnational Institute, the ETO Consortium, the University of Antwerp's Law and Development Research Group, and the Wageningen University's Center of Excellence on Corporate Sustainability and Human Rights Law. And of course, I am particularly grateful to our host, the Essex Business and Human Rights Project, in the person of Anil Ilmaz, senior lecturer at the University of Essex, who will help us coordinate this panel. I am Chiara Macchi, assistant professor of law at the Wageningen University, and I will be chairing this session, which is part one of the two-part workshop. Some of you might know already that Francesca Albanese, the UN Special Rapporteur on the situation of human rights in the Palestinian territory occupied since 1967, has just published a landmark report, From Economy of Occupation to Economy of Genocide, a report which recognizes that far too many corporate entities have profited from Israel's economy of illegal occupation, and it exposes the role of corporate entities in sustaining the illegal Israeli occupation and its ongoing genocidal campaign in Gaza. The advanced edited version of the report has just been published. Therefore, we warmly invite you all to read it and prepare your questions, because we will soon organize a part two of this workshop, which will be dedicated specifically to commenting the report itself. However, in today's part one, we lay the basis for the understanding of the legal principles that underpin the responsibility of corporations from the most diverse sectors that are contributing to the economy of occupation and genocide, or that are directly linked to it. And we will do so with the help of a panel of experts. In order of appearance, Dr. Tara Vanot, Associate Professor at the University of St. Mary's Law School, Dr. Gamze Erdem Türkelİ, Associate Research Professor at the University of Antwerp, Dr. Shahd Hammouri, Lecturer at the Kent Law School, Robert Grabosch, Lawyer at COSU Legal, and Wesam Ahmed, Head of the Center for Applied International Law at Al-Hag. Before we start with the presentations, we would be remiss if we started this session without acknowledging that some of our co-organizers and some of the business and human rights experts working on Palestine have recently been subjected to an order that would ban them entry to Israel and thereby to Palestine. For some, this means a seemingly permanent separation from their homes and from their families. The order states that the reason for this ban is that these organizations and individuals have been advocating for international legal accountability for crimes committed against Palestinians. This kind of punishment is itself a breach of Israel's international human rights obligations, and in some instances may amount to a war crime. So we want to express our concern over these developments and our care for our colleagues. So without further ado, let's start our session, which we envisage will last approximately 90 minutes. And I would like to give the floor, first of all, to Tara Vanot, because I would like to ask Tara to set the context for our discussion, particularly by reference to the ICJ cases and their economic implications. So the ICJ has issued two landmark advisory opinions, the 2004 advisory opinion on legal consequences of the construction of a wall, and the 2024 advisory opinion on the legal consequences arising from the policies and practices of Israel in the OPT, including East Jerusalem. Also, as you know, in December 2023, South Africa instigated proceedings against Israel at the ICJ, alleging that Israel's conduct in the Gaza Strip violated their obligations under the Genocide Convention. And in 2024, the ICJ agreed to issue provisional measures. Now, Tara, could you briefly outline the legal reasoning of the ICJ in these cases and reflect on their potential economic implications, particularly in terms of state economic responsibility? You have the floor.
Thank you, Chiara. I'm going to share a PowerPoint just for this part because there's a lot to discuss when it comes to the ICJ judgments. We are actually talking about, in addition to the Palestinian wall case from 2004, as Chiara just noted, there are actually 4 cases that have been decided or are currently being decided by the ICJ from 2023 until now. So we've had the legal opinion on, or the advisory opinion on the legal consequences arising from policies and practices. We have the contentious case under the Genocide Convention brought by South Africa against Israel. We have a much broader case being brought by Nicaragua against Germany for alleged breaches of multiple different kinds of international obligations for supplying weaponry and other support to Israel. And then we have an ongoing advisory opinion that was sought on obligations of Israel in relationship to the presence and activities of the United Nations and other organizations within Gaza. So today I'm going to focus really on these 3 core cases. The advisory opinion related to Israeli policies and practices, the Genocide Convention case brought by South Africa against Israel, and the alleged breaches by Germany brought by Nicaragua. So starting with the Genocide Convention case, and I am going out of order of the decision because really the bulk of the discussion needs to sit with the Israeli policies and practices case, where we actually already have a decision from the court or an advisory opinion from the court. So in the Genocide Convention case brought by South Africa against Israel, South Africa is alleging that Israel has breached or may be in breach of several different obligations under the Genocide Convention. The commission of genocide, but also the potential for incitement to genocide, the failure to investigate, prosecute, and punish genocide or incitement to commit genocide. And so the court has adopted a provisional measures order in January 2024. And that adoption of the provisional measures indicates that there is a risk that genocide is being committed in Gaza. Now, the court was very, and a lot has been made out of this. So the court didn't say that there is a direct risk of genocide. Rather, the court said that there's a risk that the convention has been breached. And that could be either the commission of genocide, incitement to commit genocide, or the failure to prevent or prosecute acts of genocide or incitement to commit genocide. A lot has been made out of that distinction, but I need to be clear that you would not have a risk of the breach of the Genocide Convention if there wasn't a significant risk of genocide being committed in Gaza. You don't have breaches of the failure to prevent and prosecute unless you are at a position where the risk of genocide is significant. The court has called on Israel to take measures to prevent and punish genocide and incitement, to ensure civilians have access to humanitarian assistance and basic services, and to preserve and prevent destruction of evidence relevant to the allegations. So Israel is on an ongoing obligation to do all 4 of these things. I will note here that public evidence does not suggest that Israel is abiding by these provisional measures. In Nicaragua versus Germany, and I'm going to come back to what the implications of that case are at the end when I talk also about the combination of the cases. With Nicaragua and Germany, what you have is an allegation that Germany is supplying weapons with knowledge that Israel is going to use that weaponry either in the commission of genocide or in other commissions of widespread and systematic human rights and humanitarian law violations. I'm just going to note that if you have questions for us, please do use the Q&A function within the chat. at the bottom of your screen. So Nicaragua has alleged that Germany is breaching its obligations under human rights, humanitarian law, and the Genocide Convention by continuing to supply this weaponry to Israel with knowledge of how those weapons are going to be used. Germany has said that Israel isn't breaching its obligations, and therefore Germany cannot be breaching its obligations by supplying weaponry. It's also said that it has a very robust arms export regime, and it's complying with that, and therefore it can't be failing to exercise appropriate due diligence in supplying the weapons. The court has not issued provisional measures in this case, although it has reminded all states parties that they're under a duty to ensure respect for humanitarian law, that they are under an obligation to prevent and punish genocide. So while the court didn't issue specific measures to Germany, there was a much broader reminding of states parties, of all states parties, that they are expected to abide by their obligations under human rights and humanitarian law by ensuring respect for that in their dealings and by ensuring that they are taking steps to prevent genocide, as well as the incitement to prevent genocide. So those two cases, I just want to briefly mention them because they set up this wider pattern in which we're going to be talking about what states are expected to do and what businesses are expected to do when it comes to Israel's dealings with Palestine. These cases were very specific to Gaza, but the Israeli policies and practices case was not. It was not about Gaza explicitly, but it also wasn't about the West Bank and East Jerusalem explicitly. So this is an advisory opinion case. And to do that, the court had to go through several preliminary questions before it gets to the heart of the questions of Israel's violations. So the first question is Israel occupying the West Bank, East Jerusalem, and Gaza? And the answer was an unequivocal yes. Occupation occurs when the state effectively controls the territory of another state or another party. The court said that Israel is very clearly occupying East Jerusalem. It is occupying much of the West Bank, and it's occupying Gaza to the extent that it effectively controls certain aspects of Gazan life and governance. So Israel controls the airspace as well as the waterways. It prohibits people leaving from Gaza. It also, or it prevents people from leaving Gaza. It also controls the imports into Gaza. And so all of that creates a situation in which Israel is occupying Gaza, just not as completely as it occupies the West Bank and East Jerusalem. The next question was, is Israel bound by the Fourth Geneva Conventions? And this was a significant question because there were interventions into the case that suggested that Israel is not bound by the Fourth Geneva Conventions. There was a loophole in 1967 that allows Israel to escape any responsibility for the Fourth Geneva Conventions. This aligns with Israel's broader policies within its own. This aligns more broadly with Israel's public statements around its relationship to Palestine, where it has often claimed that it's not bound by the Fourth Geneva Conventions itself, but it's bound by customary international law akin to the law of occupation. And the court said very clearly, Egypt, Jordan, and Israel were all parties to the Fourth Geneva Convention in 1967. That's important because Egypt and Jordan were the predecessory states for Palestine due to the mandate of the League of Nations. We can't get into all of that background, but just know that the court came out very firmly and said Israel is bound by the Fourth Geneva Conventions. It is an occupying power, and it has the obligations within the Fourth Geneva Conventions. And then there was a question of whether or not the prolonged nature of the occupation changed Israel's rights or obligations. And the court again said very clearly, no. Occupation is a very temporary situation. It is intended to be a temporary situation. The law only allows for its construction as a temporary situation. And that temporality is related to military necessity. Occupation cannot transfer title of sovereignty, and it cannot change the rights or obligations of the occupying power just by extending the length of the occupation. As a consequence, Israel is very limited in the kinds of changes it can make to Palestinian territory, including how it can use Palestinian territory. And this becomes significant when we talk about the economic relationships and activities within Palestine. Sorry, I think because of my computer, I think I just missed a fourth question. Let me go back. No, I did not, sorry. The final question is, shouldn't this have all been settled in line with the Oslo Accords through a negotiation? There were several different entities that intervened and said, the court shouldn't even be making this decision. All of this is governed by Oslo, and we should just pay attention to the negotiations. And the court said, actually, no. The Oslo Accords are to be interpreted in line with human rights and humanitarian law obligations. And the Oslo Accords themselves affirm that, saying that the parties are bound by their existing international obligations. Beyond that, the Fourth Geneva Convention says that the parties can't negotiate away the rights of the occupied population. So the occupied population is entitled to the rights protected and provided by the Fourth Geneva Conventions, and you're not allowed to come up with agreements that breach that or that lessen their rights. So Oslo can exist. The negotiations are a means by which to implement international law, but fundamentally, these are legal questions that the court has a right to decide. And so when it comes to the findings of the court found in whole that the settlement enterprise within Palestine, by which Israel establishes settlements, promotes them, takes advantage of them, and exploits the natural resources through them, all of that is illegal. It's all in breach of the Fourth Geneva Conventions. The settlements are illegal, the outposts are illegal, and Israel's policies and practices that involve the inducement to settle, the legalization of the outposts, and the confiscation of property and requisitioning of land for the benefit of the settlements are all unlawful. The court was very clear that any confiscation of private property, even for military necessity, is prohibited, and the administration of public property has to be for the benefit of Palestinian people, meaning it cannot be for the benefit of the Israeli population or the settlement population. It is all supposed to be done for the benefit of the Palestinian people. And that's because fundamentally this territory belongs to Palestine and therefore to the Palestinian people. Within that context, the court was also clear that the exploitation of Palestinian resources is unlawful. This is both the natural resources, as we think of in terms of Dead Sea minerals, but also the water, also things like quarrying, rock consumption. So for a very long time, we have heard Heidelberg Cement claim that its activities in the West Bank are not in breach of humanitarian law and do not constitute a war crime because they're not taking so much property. Like, it's fine, there's going to be enough rocks later, Palestinians can get over it. And what the court has said very clearly here is actually that's not the legal standard. The Hague Regulations, Article 55, which is customary international law. The Hague Regulations, by the way, are like the little sister to the Geneva Conventions. Everyone knows about the Geneva Conventions and no one knows about the Hague Regulations, but the Hague Regulations are actually really important for humanitarian law. And the Hague Regulations limit Israel's rights to natural resources so they can administer natural resources and they can, it's called usufruct, meaning that they can use the sort of excess of the territory, but only for what's militarily necessary. So it has to be necessary for the benefit or for the administration of the occupation. It can't be used for the benefit of the population, of the Israeli population, and it can't be used for the benefit of the Israeli military. It is what is necessary to sort of make sure that the occupation is effective and governed appropriately. Anything beyond that is an abuse of Israel's rights as the occupying power. So all of that exploitation is unlawful. And in addition to the settlements being unlawful, in addition to the use of natural resources being unlawful, the court found that Israel is also in breach of several other obligations under the Hague Regulations and the Geneva Conventions by expanding laws to include Palestinians. So Israel, as an occupying power, is very limited in the kinds of laws that it is allowed to impose on Palestinians. It's also in breach of the UN Charter because it has attempted to annex East Jerusalem by law and the West Bank by a combination of law and facts. Israel's also breached the prohibition on racial discrimination, including, importantly, what's known as the Convention on Elimination of Racial Discrimination's Article 3 prohibition, which says that states will not institute systemic racial discrimination or apartheid. The court didn't say exactly whether or not what Israel had done was serious racial discrimination or apartheid, but that Article 3 is where we find the prohibition on apartheid within the Racial Discrimination Convention. And it's quite significant that that's the article that the court really picked up on when it came to racial discrimination. And it delineates quite clearly how Israel is committing what is probably akin to apartheid. The home demolitions are unlawful. They are unlawful under several different clauses. And finally, Israel is breaching Palestinian right to self-determination. So the court was very clear that Palestine as an entity is one unit. So East Jerusalem, the West Bank, and Gaza are one territorial unit, and the population within that territorial unit has the right to exercise self-determination, meaning that they are allowed to govern themselves and they are allowed to exercise that to the exclusion of Israeli governance. The most significant findings of the court come in paragraphs 261 and 262, where the court said that these kinds of abuses have been so sustained that, that it has rendered the entirety of the occupation unlawful, and that the illegality relates to the entirety of the Palestinian territory. So here what we're finding is that the court is saying, actually, Israel has abused so much its rights as an occupying power that while occupation in and of itself is not illegal under international law, in this particular circumstance it is. And the entirety of the occupation becomes unlawful by its nature. This finding has several legal consequences. So there's legal consequences for Israel, and then there's legal consequences for other parties. The consequences for Israel include that the occupation is internationally wrongful, meaning that Israel is under an obligation to bring about the end of its illegal occupation. It has to cease all new settlement activity. And finally, it has to provide full reparation for the damages it has caused. Those are what Israel has to do. But other states also have obligations that arise because of Israel's unlawful conduct. First, they are to distinguish between Israel and Palestinian territory. States are prohibited from acknowledging as lawful Israel's unlawful activity. So any efforts by Israel to annex, any efforts to develop settlements, states have an obligation to reject that. And then the two most important clauses or findings from the court relating to economic activity say that third-party states must abstain from entering into economic or trade dealings with Israel concerning the occupied Palestinian territories, and they must take steps to prevent trade or investment relations that assist in the maintenance of the illegal situation created by Israel. Now, these findings are very specific to the general policies and practices of Israel, but they can also be understood as the obligations that flow from other forms of illegal activity by Israel in relationship to Palestine. So this brings us back to the Nicaragua versus Germany and to the Genocide Convention case. The provision of weaponry to Israel, when it is known that it will be used either for war crimes, crimes against humanity, violations of human rights within Gaza, or in the establishment of settlements, the maintenance of the settlements, or the occupation of the West Bank and East Jerusalem, all of that constitutes an unlawful act. And all of it means that states have to take steps to ensure that their economic relationships with Israel do not give Israel license to continue to settle, to continue to operate settlements, to continue to engage in aggressive use of force within Gaza. All of that has an economic consequence for states, and they are to regulate not just their own activities, but also those of their nationals. That's what that second out of the two bolded clauses means, that second clause. Means that they have to start regulating their corporations better and making sure that their corporations are also distinguishing between Israel proper and the settlements, or between Israeli activities in the 1967 boundaries and those that take place outside of those 67 boundaries. Sorry, Chiara, I know that was a very long answer, but there's a lot within these cases that we really need to think through when it comes to what states are obligated to do.
Thank you, Tara. It was a necessary answer, and thank you for setting the context and for your focus on state responsibility, which now allows us to actually move our focus onto corporate accountability. And so, given the context that you have just illustrated, Tara, how should the UN Guiding Principles on Business and Human Rights be applied in relation to the economic activities linked to the occupation? And by activities, we're not just referring to arms and dual-use technologies, but also the activities of corporate actors like Google or settlement-related businesses, or even the issue of paying taxes to Israel. Can you please give us some insights into that? Thank you.
Yeah, so the UN Guiding Principles affirm states' ongoing obligations to regulate their businesses, and that includes, through elaboration since the Guiding Principles were adopted, that includes an extraterritorial obligation, and we see in the court's judgment itself an ongoing obligation to regulate corporate activities within Palestinian territory when it's for the benefit of Israel. But in addition to the state's obligations, the guiding principles recognize that all businesses have a responsibility to respect all human rights in all contexts and at all times. And to do this, they're to undertake human rights due diligence, meaning they're to assess their operations, policies, practices on the ground in consultation with stakeholders to assess how their activities are impacting on human rights and what they should do to mitigate those impacts and to remediate any harms that do arise from their activities. But I want to be clear that the guiding principles are not a self-contained unit. They derive their content in terms of human rights and humanitarian law violations from the rest of public international law. So it is not enough for businesses to say, this is complicated. When the court has said very clearly that the entirety of the occupation is unlawful, that Israel has abused its policies or its powers as an occupying power and its authority, that the exploitation of natural resources has to be for the benefit of the Palestinian population, and it's not, that the water consumption within Palestine is being redirected to the benefit of the settlements in breach of the laws of armed conflict. All of that has to factor into the assessment of what businesses are doing on the ground. It means that any activity within the settlements themselves is unlawful. Any use of water that has been directed to the settlements is unlawful. All of that is participation in war crimes. All of that has to factor within businesses' human rights due diligence. And I need to just hone in on this point a little bit more, because I think a lot of times businesses say, oh, but the guiding principles say the Universal Declaration of Human Rights. We're supposed to pay attention to the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, and the Universal Declaration of Human Rights. Says nothing about the Hague Regulations. How could we possibly have been asked to understand the Hague Regulations? And that's a really bad reading of the guiding principles. And if that is your reading, I suggest you go back to your elementary schools and complain because they did not teach you reading comprehension skills. What the guiding principles actually say is all human rights, and you can start with this. You can start with the International Bill of Human Rights, but you're also supposed to comply with humanitarian law as a matter of obligations and compliance. And so that brings in the Hague Regulations and the Geneva Conventions. The guiding principles are also clear that other human rights may be applicable at times, and you need to consider them in consultation as well, through consultation with stakeholders. And this is where I want to loop back to what we mentioned before about the attack on human rights defenders. This is not this ban on our colleagues and our friends working on business and human rights in Palestine. This is not the first time that this has happened. We have Wesam here from Al-Hag. Al-Hag has been designated, along with other NGOs, as being a terrorist organization. I'm going to assert that if you cannot convince the United States that Al-Hag is a terrorist organization, then you're probably just making things up. And so there is not enough evidence to sustain those allegations. If there were, both the EU and the United States would have been endorsing Israel's classification. They have not, for good reasons. This ongoing attack of human rights defenders isn't just a problem for Palestinians. It's actually a problem for any corporation that wants to do any business anywhere in Israel and Palestine. And I'm saying that because you are supposed to be doing this in consultation. You are supposed to be doing human rights due diligence in consultation with human rights defenders and stakeholders. If your human rights defenders cannot speak out without fear of repercussions, without fear of being forever exiled from their families and their homes, you cannot do adequate human rights due diligence. You don't have the buy-in on the ground to be able to get access to the information that you need to understand the implications of your activities. You can't do human rights due diligence. And if you can't do human rights due diligence because you can't access Palestinians, you can't access Palestinian human rights defenders, it is not just about the activities in the settlements in the West Bank. It is about all the activities throughout Israel. Because it's not just, Chiara, you mentioned the dual use weaponry. Google providing services to Israel does not simply affect Israelis. That's not your only stakeholder group. The other stakeholder group always implicated when you are providing weaponry to the IDF or to the IOF, all of that is implicating Palestinian stakeholders, meaning you have to be in consultation with Palestinian stakeholders when you are providing dual use goods to Israel. And if you're not doing human rights due diligence from the start. You might be doing lots of other interesting things, but it's not meeting the basic qualifications for human rights due diligence. And that's a problem. So what we're seeing now is a lot of businesses that are in breach of their human rights responsibilities because they're not doing the adequate human rights due diligence from the start. What does that mean? Under the guiding principles, they have a responsibility to mitigate and remediate their harms. Remediation in this case is both procedural, so there should be a way for Palestinians to complain to the businesses. Google should have a process set up for Palestinians to say, hold on, you're about to provide them with this cloud-based technology, and it's going to impact our abilities to free movement, our ability to right to fair trial, our ability to freedom from torture, our ability to right to freedom of expression. All of that is implicated. So you have to have the process set up, but you also have the substantive reparations. So there are obligations of restitution, there are obligations of rehabilitation, there are obligations of guarantees of non-recurrence, which means that you take policies and practices and change them to ensure that you are not constantly harming human rights through your activities and through your relationships. That can include things like contractual clauses in any sales or arrangements that you do have with Israel proper. And then finally, financial compensation. So I am going to assert right here, right now, that within 5 years, Google will owe significant reparations, significant financial compensation to Palestine as a government and to the Palestinian people. And I'm giving myself 5 years because I don't believe the sale has actually gone through fully yet. So I don't think Israel has full access to, I promise I'm wrapping up, does not have full access to the equipment. But we do know from Israel's policies and practices and from that long list of violations that the International Court of Justice has found already, that they are going to use any equipment that Google provides them in breach of human rights and humanitarian law, and in breach of Palestinian human rights and humanitarian law, because that's what we have in terms of a historical record. And while history doesn't always repeat itself, it does often rhyme. And so we are going to see those violations continue. We're going to see new violations pop up because of the new technology. And with that will come an obligation on Google to provide significant financial compensation. And hopefully we will see a lot of court cases that facilitate that, although I'm sure we're about to hear all the barriers to that. Sorry, Chiara, I know I went long. Thank you, everyone.
Thank you. Thank you, Sarah. Thank you very much. And actually, your question links well to what I'm going to ask our next speaker, Gamze Erdem Türkelİ, because you mentioned, of course, human rights due diligence and the fact that the UNGPs bring in the necessary standards when it comes to conflict-affected areas, occupation contexts, and when it comes to particularly vulnerable right holders. Gamze, I would like actually to ask you, following Tara's remarks, could you elaborate on how children's rights introduce heightened due diligence obligations for corporations operating in or linked to the occupied Palestinian territories?
Thank you, Chiara, certainly. So what we know of children's rights is that the Convention on the Rights of the Child is almost universally binding by virtue of being ratified by all states in the world, with the exception of the United States, which means that for businesses, wherever they operate, besides domestic law and protections for children under domestic law, international children's rights frameworks will also apply likely by virtue of often both of the host state and the home state being parties to the convention. And there, in Article 38 of the CRC, the Convention on the Rights of the Child, we have the obligation to respect all norms of international humanitarian law. So linking to Tara's point about the Geneva Conventions, the additional protocols, and in fact, those protocols, so the Fourth Geneva Convention, as well as the protocol, the additional first protocol, provide additional protections to children, not only the baseline protection for being civilians, but also the added protection, completely being protected against any form of indecent assault, but also to provide children with care and aid that they require. And we know this has been really a catastrophic situation for children, especially what's been happening in Gaza in that respect. And as Tara has already noted, the UN guiding principles, but business and human rights frameworks more generally, they entailed heightened due diligence in situations of armed conflict, but they also introduce heightened due diligence for certain individuals and groups, as Chiara, you were noting. So children are a part of that cohort, but also women, older persons, persons with disabilities are also sort of groups where enhanced protection and heightened duties for businesses apply. So what it means is in situations of armed conflict, where risks of violations are much sort of higher, and the company's risks are therefore higher, due diligence duties are doubly heightened, both because of the conflict in question, but also because of children being sort of a part of that scenario. And the Committee on the Rights of the Child, in its General Comment 16, has also said that businesses have the same responsibilities to respect children's rights in conflict situations as they have elsewhere. But of course, the risks, because the risks are higher, the due diligence requirements are at a higher level. And that's true for all armed conflict situations taking place with respect to children's rights, whether it be Palestine, the Democratic Republic of the Congo, Sudan, to name a few. But when we turn to the situation in the occupied Palestinian territories in Palestine, particularly in Gaza, which UNICEF and many other civil society organizations have called a war on children, we know that children make up half of the population, and that in Gaza, and that figure is around 40%, a little more in the West Bank. And we know that indiscriminate attacks against civilian infrastructure and civilian population have resulted in disproportionate killing and injuring of children. The latest figures, sadly, from mid-June of this year, point to identified fatalities, so not the, of course, unfortunately, not the whole number of fatalities, but those who have been identified, that's around 56,500 people, 17,000. And let that sink in. 17,000 of those are children. There are 133.5 thousand people reportedly injured, and medical personnel have been letting us know for months that Gaza has the largest cohort of child amputees than anywhere else in the world. We've seen terminology developed to denote children who were injured, wounded child, no surviving family that had no one to take care of them. In the West Bank, and I don't want to exceptionalize Gaza, but if we look at the West Bank, we have known for decades that there are violations of the right to life of children, as well as arbitrary detentions, arbitrary killing, inhuman treatment, to name a few. And what this factual situation is showing us, not just in the last 20 months, but for decades, that in relation to children's rights, they're not just potential risks of violations that companies have to take into account in their due diligence, but these risks well, these are violations that have materialized. So what is a risk is not the violations happening. What is a risk is that the company may be implicated, the business enterprise may be implicated in those violations themselves. And that concerns not only businesses, I would say, that are involved in supplying parties, parties to the conflict in conflict situations. It's, as Tara explained, that whole systemic nature of how the occupation has been operating. It's really any company that is undertaking any engagement. And so, indeed, because I think we know the numbers, we have the factual situation in front of us, we have the evidence. And for companies, their heightened due diligence duties mean that knowing what they know, knowing what the entire global public knows, that these risks for them to be implicated are indeed too high. And for children's rights especially, they have to take that sort of in addition to account. And that means when they're assessing their risks, if they're able to do it, as Tara was pointing out, it may not be even possible to do it, but when they're taking it into account, even if they're reluctant on other fronts, the children's rights violations in question should also point to, the fact that there's too high a risk of being implicated in all of these different types of violations of different types of international laws.
Thank you, Gamze. And actually, I would like to take the opportunity of asking you something else, because we have so far focused on corporations, and of course, we will go back to that in a minute. But I also wanted to ask you, what are the responsibilities of other types of institutions, for instance, universities or other types of private or public-private actors? What responsibilities do they bear under the business and human rights framework?
Yeah, I think I'll link it to Tara's one of the very last points Tara made about this not being just a kind of business dealing issue, but more of an economic ties and relationships issue, especially when it comes to engaging with what is an ongoing, prolonged illegal occupation that entails a number of breaches of really some of the most fundamental norms of international law. And so universities, other types of private actors, I would say international organizations, supranational entities like the EU, all know what we know. We all have a public knowledge of the systemic violations of human rights law, humanitarian law, international law being perpetrated. And we all have access to that information. And if our institutions are engaging in economic dealings of any sort, then these, in fact, I would say not just due diligence obligations under business and human rights, but also just obligations under international law more generally, and looking at peremptory norms of international law that are being violated, that the International Court of Justice last year in July has said are being violated, but those violations create erga omnes, to use sort of jargon, so obligations incumbent on the international community as such. And all those institutions, when they're engaging in any types of institutional dealings, economic dealings, are a part of that international community, and they have to actually not do harm and not be, I guess colloquially, the term is complicit, but not to render aid and assistance in legal terminology to the illegal situation, as Tara has outlined. And I think especially looking at what's been happening in the sort of academic frameworks, there were questions. Well, what's the harm in engaging in research, let's say, on cancer? But of course, it's the systemic nature. So it's not individual collaborations. It's not that's being called into question. It's really the fact that the risks of being involved in aiding and assisting a situation that has been deemed illegal, was deemed illegal already 20 years ago in the Wall Advisory Opinion. And it's rendering that aid and assistance that puts you at risk of being complicit in those violations. And I think for European companies, universities, we also know that the EU's own External Action Service a few weeks ago concluded that Israel is in breach of Article 2 of the Association Agreement with the EU, that is on respect for human rights. So indeed, it has been ascertained what the EU states will do and the Council will do with that knowledge is we don't know yet, but the institutions are aware of this. And when they're doing their due diligence risk assessment, I think what I'll conclude with is to say that they have a duty to act within a strict due diligence framework. And they have to, I think, at this point, depart from a precautionary principle, because if they cannot ascertain, they cannot ensure that they will not be involved in any way and linked to the violations, if that is impossible to ascertain, then I think at this point, engaging in that institutional or economic relationship is indeed not permissible.
Thank you very much, Gamze. Thank you for this very clear picture. And actually now I would like to move on to the possible consequences for businesses in particular of failing to do their heightened due diligence in this context. And Shahd, I would like to give the floor to you and ask you if you could kindly share your perspective on the lessons to be learned in this context we are describing. And in other words, what do companies risk if they don't do their heightened due diligence in a context in which they are at high risk of complicity with international crimes? Can you give us perhaps some examples of ongoing cases? Over to you, Shahd.
Thank you so much for that, and thank you for my colleagues. It is indeed an honor to be here with such great colleagues today. And indeed, as we speak of abstract things, as clearly reiterated up until now, the context of which we speak is that of unimaginable suffering that has scarred the consciousness of humanity. And as we speak, despite the abstract nature of the laws of which we speak, we must recognize the historical moment and failure of humanity that stands in the background of our discussion. So in reality, what we are seeing is that corporations have still been very reluctant to actually call a spade and articulate the risks that they are accepting by the mere fact of engaging with the Israeli economy on multiple levels. As noted by my colleagues, economic activity inside of Israel now indeed is bears a high risk of engaging with a multitude of laws, including tax laws, nationality laws, visa laws, you name it, the water that you would be benefiting from. So it's almost impossible to disengage the illegalities that Israel is committing in the occupied Palestinian territories, as well as its own economy, since its own economy is very heavily militarized into sustaining this war economy. And that will be very clear once any corporation does its due diligence and takes seriously the evidence presented by both the United Nations, Palestinian human rights organizations, as well as international organizations about the reality of what is happening there. So the risks of engaging in the Israeli war economy are indeed very high. To begin with, there is a very heightened risk of litigation, and I will go into the very different possible pathways for litigation in a few minutes. And then there's, of course, shareholder scrutiny and lawsuits. We've already seen a lot of shareholder activism in big corporations such as Microsoft and Google. And this will, in the future, 1 year, 2 years from now, level up to lawsuits. And that is because of the damage that we will see happen to these corporations as we go along. As noted by my colleagues, Francesca Albanese has just issued her latest report on some level on the economy of the occupation, but on another level on corporate involvement in the war economy. And there is a long list of corporations that has been named based on the historical number of submissions that were given to Francesca in this report, which is over 200 something, very solid contributions. So we're already looking at the blacklists that are created, as well as high litigation through OECD contact points. As far as I know, I've already heard of cases in Denmark, Belgium, France and the UK, whereby people are going to the OECD submitting complaints for non-compliance with the OECD guidelines on multinational corporations. Indeed, there's of course the reputational damage, as we see, for example, with the case of Maersk, the Danish company. We have seen that there is now mass targeted mobilization against it, especially youth-led in this case, people who are inherently simply conscious and responsible actors, as well as in a lot of cases consumers. We have seen also very big boycott campaigns, specifically in Muslim and Arab majority countries. So, for example, I was just in Jordan. It's almost an offense to drink Coca-Cola. Even the airline serves the new branches of that, which are Matrix and whatnot. On some level, of course, this is good because it overcomes some of the monopoly based by these corporations, but we would see that to a very high level. People are not buying L'Oreal. Carrefour has been shut down in multiple jurisdictions, and it's quite insane that corporations are not taking the effect of those campaigns into consideration when they are undertaking their own both financial risk analysis as well as human rights due diligence. So then there is exclusion from funds that require very high level of compliance with human rights standards, as well as funders such as pension funds. We've already seen a lot of pension funds that are divesting from corporations that have been found to be complicit, and also the refusal to use these to engage with companies that are found to be not compliant. So, for example, Barclays, we've seen high divestment by very big organizations and associations affiliated with it, and also bad economic indicators for engaging in the Israeli economy. As far as we know now, both Fitch and Moody's have lowered the credit rating for Israel, and also we expect that there is a lot of backlog that still hasn't been reflected in the financial indicators, and that is indeed due to not only the fact that this is a illegal occupier, as well as a country currently undertaking genocide, as well as unimaginable crimes in the Palestinian territories, but also because this is a country that is currently ruled by an inherently racist government that has demonstrated a very high influx and appetite for aggression, not just in Palestine, but also, as we speak now, Israel is committing unlawful aggression also in Syria and in Lebanon, even though you don't hear about it in the news. But every day there are people killed in both Syria and Lebanon. Israel's control over any areas of Syria, that being the Julan Heights, is completely illegal on so many levels. It's a threat to international peace and security. And indeed, of course, its violation of the ceasefire agreement with Hezbollah is also a threat to international peace and security and unlawful aggression, as well as its unlawful aggression against Iran. So all of that means that this is not a country to trust to put your money in, given that it's also putting itself at risk of war going forward. There is huge loss of capital and talent inside of the Israeli economy that Israel is doing its best to kind of cover up, but the turbulence of all of its irresponsible behavior has been showing itself in the amount of capital that's leaving the country. And last but not least is the upcoming sanctions. While the world has still managed to not respond to their economic third state responsibility, kindly noted by Tara, however, there is very little space for these sanctions not to be taken forward, because even though the political status quo stands behind Israel, what on the other side, there is the fact that Israel is breaching the very fundamental foundations of international law. So we're going to reach a breaking point, as per UN experts, where international law is currently at a knife's edge. It is either that we take forward Israel's violations of international law, or that we instill a sanctions regime. Next week, in the next 2 weeks, we're going to see the ministerial conference of the Hague Group, and we see many more countries join the Hague Group, which is a group of states that have vowed to uphold the rule of international law, a very basic thing these days, while states of the global north, primarily European and American states, have the US, as well as, of course, the other settled colonies of Australia and Canada, have managed to completely disregard this law in the most awful way. But this is not a sustainable situation at all. So while we currently look also to different different parliamentary actors asking for sanctions. We're also looking at different councils looking for sanctions, and we're also looking at smaller states coming in. So we expect a larger influx of sanctions, and for corporations to be operating in an economy that might possibly be heavily sanctioned, further sanctioned in the future, is indeed yet another escalated risk. So keeping all of that, all of the things that I just mentioned, should be a very high red alert for any corporate compliance department looking at either financial indicators or human rights indicators, and indeed them putting them together. What we're seeing is actually a very bad practice by such compliance departments. For example, the compliance department of Microsoft has managed to put out completely false statements about the company's compliance with its human rights due diligence. What it did is that gave very vague answers to shareholder questions in relation to its compliance, despite very solid evidence of its contribution through Azure or other technologies in facilitating suicide drones, in facilitating cloud space for those, and AI technology that is being used to commit the most horrible of crimes. You can't even imagine the testimonies that I've heard of how these AI drones have been used. One AI technology to target people, and indeed, if it is Israel that is giving the input, then any moving Palestinian is dehumanized based on the information that we heard. I have a friend of a friend who yesterday told me that that they heard of in their neighborhood a mother who was being targeted with a drone, who was then killed by it. Or, for example, drones that are making baby noises, whereby people go to think that there is a baby in distress and then they get bombed themselves. It is indeed the most unimaginable levels of abuse using these technologies. So for Microsoft to come up and say that, oh, our human rights due diligence tells us that there is no risk down the way, that is blatant lying. And in the future, what this will mean is that not only will shareholders be facing material consequences, that we will see lots of more shareholder action in relation to this very irresponsible behavior by compliance departments. So, and moving on to my next point, which is we are currently seeing a high rise in litigation against corporations involved in the Israeli war economy. So, and the first step for those who are also thinking in terms of advocacy is to send cease and desist letters to these corporations. As we've currently outlined, the corporations that are involved in the Israeli war economy risk very high risks of violating their human rights due diligence obligations. And they also risk complicity in the multitude of violations that Israel is committing. So cease and desist letters have been heavily used by, for example, organizations like the Center for Constitutional Rights, as well as other human rights organizations. Most recently, we've had Sidinor, which is a Spanish company. There was a very big letter that was sent to it in relation to its export of steel to Israel, and luckily enough, yesterday we got the news that Sidinor has responsibly decided to disengage from its investments with Israel. And we see, of course, a number of similar examples. There's also petitions by lawyers. We've seen a lot of lawyers make submissions, expert lawyers making submissions to corporations and warning them of the risks that they're taking. We've seen that with Microsoft and Google. And then after those letters are being sent as a warning, and after, of course, we've had publications, op-eds, for example, the Business and Human Rights Resource Center is now full of cases that have been where the companies have been officially noted of the high risk that they are taking. And indeed, of course, companies shouldn't be waiting for such letters, because the UN reports coming out of this, as well as we already have a database, but going beyond that, there is the most recent database by the rapporteur, adding to that, of course, all of the legal resources that my colleagues have noted. So claiming ignorance here is not really an excuse. So then we see tort claims against parent corporations. Thanks to the business and human rights discourse in the past 12, 13 years, we've seen a very high rise in engagement in legal frameworks that respond to this need. Of course, we're still at a fraction of what needs to happen. However, this really builds on to this really builds onto the momentum, because in cases of conflict affected cases are cases of extremity that really lay power relations bare and facilitate the evolution of such lawmaking efforts. So here we, of course, cases like Vedanta, for example, will work as really good precedents to establish parent tort claim liabilities. As we speak now, there is a case against BP for in the UK for negligence in its operations in the Baku-Tbilisi Kayhan BTC pipeline, whereby the BP is supplying oil to Israel, is facilitating the supply of oil to Israel via Azerbaijan pipeline going through Turkey into Israel. And that case relies on negligence as the premises, and it's been raised by Binmans as well as ICGP, with, of course, a good number of Palestinian claimants. Meanwhile, another option is criminal cases. As you're all very well aware, corporations can be held complicit in genocide. This is something that has been reiterated by prior ICC prosecutors, but also the Special Tribunal on Lebanon has 2 or 3 years ago asserted that corporations can be held responsible under international criminal law. There is a very long list of literature on this. We see institutional reluctance, but that doesn't mean that in theory it can go ahead. For example, we saw ECCHR go ahead a few years ago with a very big case against CEOs of arms corporations supplying in that case, to Saudi Arabia for weapons to be used in Yemen. And there's currently, of course, multiple similar cases in relation to arms corporations supplying to Israel. Usually in that case, the first line of litigation has been to go directly to the state and challenge the licenses. But in this case, also we have direct criminal responsibility, and of course with the precedent of the industrialist trials, which really helps. So of course, this is not a form of litigation that can only be undertaken in international courts, but under universal jurisdiction. We have the cases of Lafarge and London to build on, and we also have cases in relation to Palestine, for example, as Exilia Technologies in France. There was a case against it, a direct criminal litigation for its supply of parts of weapons. Meanwhile, we're also currently looking at a rise in the use of committees and regional courts like the Inter-American Committee, as well as the African Court of Human Rights. There are currently multiple cases going there in relation specifically to the arms industry as well as the energy industry. And indeed, we are looking at building on other not so traditional mechanisms like OECD national contact points, as well as UN special procedures. In this case, it's very, very, very important to note that ad hoc accountability mechanisms are the precedents and the norms in this case. We are looking at a case where a state has decided to put in a privatized company that shoots on aid seekers with an average of 35 to 70, 100 people killed per day while waiting on aid. It has created the Hunger Games of aid. It has created a space where we have a new form of warfare called medical warfare, whereby 35 hospitals in Gaza have been completely demolished. So this kind of status quo is indeed not a sustainable one. So when that status quo reaches, as I said before, its ultimate breaking point, we are looking at also ad hoc accountability mechanisms. In the case of South Africa, when the world didn't expect it, when the world normalized it, we then saw the breakdown of the regime, and we also saw, for example, the public tribunals for transnational corporations at the United Nations, where big corporations like BP were questioned in front of the whole world for their complicity in the crimes committed by the apartheid regime. Also, cause lawyering and creative lawyers are now looking at and consumer laws, local council laws that have been very effective in Belgium. So sorry, I'm done. And other financial laws. And I'll just finish on the following note, which is that as we stand, international law is at a knife's edge. And the violations that have been put forth, as well as the complicity of states of the global north. This is not a sustainable thing. And it is the duty of economic institutions and private institutions to take that risk, as well as the seriousness of the violations seriously. What seems to be morally open to questioning now, history will not forgive, and if not now, then when? Thank you so much. I'm sorry I took too long.
No, that's fine, Shahd. Thank you so much. And actually, the picture that you have just presented allows me now to ask Robert Grabos, sorry for mispronouncing your surname probably, to to talk about indeed one of the cases that he's been involved in, because Robert is one of the lawyers supporting the complaints that Palestinians have filed against the German company Axel Springer regarding the company's contributions to land grabbing by the settlers in the West Bank. So Robert, could you please tell us more about that case?
Thank you so much, Chiara. You pronounced my name just right. Thank you for having me on the panel. I apologize in advance should I seem a bit slow or confused. I just got off the plane a couple of hours ago from Indonesia, back in Berlin now. But I really am happy to be on this panel because I want to tell you about an important case that complainants filed at the German Supervisory Authority, BAFA, against a German company group that provides settlers with the digital infrastructure for finding their properties in the West Bank. This case is under the German Supply Chain Due Diligence Act. Since 2023, this law requires large German companies to identify and mitigate human rights risks in their supply chains, and even more so in their own business area. This concerns labor rights and human rights, some environmental risks also, but among others, the unlawful eviction and the unlawful taking of land, forests, and waters, the use of which secures the livelihood of a person. So here we have a German law in force already, requiring German companies to avoid contributing to land grabbing. That said, what I show you now is an advert that is published in Israeli print media. What you see here is on this advert, Israel with expanded borders, including East Jerusalem, Gaza, and Golan Heights. And this is an advert for the company Judge Stein, Judge 2, an online platform much like Craigslist. Judge Stein is Hebrew and means second-hand. And the text here at the bottom of this advert reads in English, Judge Stein helps you look forward, build a future in your next home in Israel. There is Judge Stein, and we have no other land. So this platform, Judge Stein, takes no precaution to avoid land sales, land transaction taking place concerning land from Palestinians by settlers. Quite the contrary, it is well known that Zionist settlers are preferred on this platform. And the Israeli company that operates this platform, Judge Stein, is an Israeli limited that is ultimately 100% held and controlled by the Axel Springer Group. Axel Springer is a German, and now I need to stop sharing the screen and I don't know how to. There we go. Is a German media company running the most widely read and watched print, online, and TV media. And Axel Springer makes no secret of being a Zionist company. Principle number 2 of their company policy, the so-called Springer Essentials, provides that all employees of Axel Springer must act in the interest of the Israeli state. So much for independent news in Germany. And what you see here, what I show you now, is the headquarters of Axel Springer in Berlin. And I've taken this short clip in March, and when I zoom in here, you see among those flags of Axel Springer and between those flags of Axel Springer and the Ukraine, there's the Israeli flag in front of the Axel Springer headquarters. Oh, sorry. There you go. This is the headquarters of the Springer Group in Berlin. So Springer's involvement in the West Bank settlements has been known for 1.5 years. The media, the newspaper, the online paper, The Intercept broke the story in February 2024. And the German authority supervising companies' compliance with the Supply Chain Act should have initiated investigations then at that time. And to make sure that the supervisory authority, BAFA, would do so, a group of lawyers, that's me and 10 other lawyers from Israel, Palestine, and Germany, helped 5 individual Palestinians and the villages of Mada, Iskaka, and Taipei, just north of Ramallah, file a complaint at that authority. The complainants are represented by a Palestinian NGO, JLAC, the Jerusalem Legal Aid and Human Rights Center. And despite Germany's strong alliance with the Israeli government, we initially had good hopes that the supervisory authority would act, because for decades the German government has stated that it opposes the settlements in the West Bank. Germany has continuously and consistently called for a two-state solution, for peace in the West Bank, and just recently in November voted in the UN General Assembly that Palestinians must have full sovereignty over their resources. And Annalena Baerbock and Olaf Scholz said last year in interviews that the settler violence has to stop, the settlements must stop. So we had good hopes that BAFA would at least initiate investigations against Springer. However, a month after the complaint was filed in November, we received a note from BAFA saying that it intends to reject the complaint for 2 reasons. First, the complainants cannot be identified because they were anonymous. And second, the settlers do not qualify as suppliers in terms of the Supply Chain Due Diligence Act. So we responded to BAFA saying that both reasons are not convincing. First, we explained to BAFA again that the individuals are facing a threat to life. So we need to keep them anonymous, or at least protect their identity from disclosure to the opponent, as BAFA has done in similar cases. And second, the settlers may not be suppliers, but the human rights violations here already start in Axel Springer's own business area, because Springer controls this listing site, and this listing site is intended and designed and advertised to expand the settlements. So thereafter, for a while, BAFA didn't respond. And then I called them in January to discuss this again. And the BAFA staff members, the BAFA officers that I spoke with, they were very understanding. They said immediately, yes, in other cases where complainants were facing threats, they also found a way to protect their identity. We discussed different ways to do so. And BAFA saw the need, and BAFA said that they will get back to us by next week and offer a solution to move on with the case, to verify that the risks actually exist for these 5 complainants without revealing the identity of the complainants to Axel Springer. So that sounded very promising and good. And however, then 3 months later, without further ado, BAFA surprisingly sent us a formal rejection of the complaint, saying simply that the 5 individual complainants are not identified, and that the 3 villages are no rights holders for the purposes of the Supply Chain Act. So this really was disappointing and surprising also, because BAFA was breaking its promise here. it is treating Palestinians different to other complainants. It broke the promise it made to us, at least on the phone, and it is not providing any effective access to justice. And the reasoning that villages or cities or provinces or whatever cannot be rights holders is quite daunting also and disappointing, because this Supply Chain Act addresses the risk of the unlawful taking of land, waters, and forests that are used by people. So when you look at public land like streets, schools, hospitals, and forests and whatnot, land that is typically owned by communities like a village or a city, who else could possibly file a complaint if not that community? So this makes little sense, at least to us. And I believe that BAFA in reality is simply at this point doesn't want to protect Palestinians' human rights, or perhaps it is the German government that has instructed BAFA to remain inactive. In any case, what we see here is a missed opportunity of the German government to uphold international law and to protect human rights, and also to comply with the advisory opinion of the ICJ of last year. And yeah, this really makes it clear, unfortunately, that Germany is departing from international law at the moment and has given up to a large extent on human rights. So at the moment, an objection against the rejection has been filed at BAFA, and that means that BAFA has a chance now to review its decision, and it will take another couple of weeks or maybe months until we know if BAFA changes its opinion. That's it.
Thank you, Robert. Very interesting and disappointing at the same time, as you say. But that's a very interesting perspective on how due diligence laws can be leveraged. At least we can try to do that to obtain corporate accountability. And actually, I would like now to give the floor to our last speaker, Wesam, because of course with Al-Hag, you have a long-standing experience initiating corporate accountability lawsuits, and I'm sure you know the ins and outs of the main challenges that these kind of lawsuits face. So I would like you, Wesam, to close this panel, to help us close this panel by focusing on indeed the challenges that need to be overcome in order to establish corporate accountability. Thank you.
Thank you very much for having me, and it's a daunting task to follow all these excellent speakers and my fellow panelists. I appreciate it. I've learned a lot in the discussion, and I think I've gone through a series of emotions of a little bit of optimism, back to pessimism, and I think this is the nature of our work, and constantly trying to turn over every stone, because we know it's an uphill battle. This is an asymmetrical power dynamics. You got the colonizer and the colonized, and so it's naturally going to be an uphill battle. And the tools that we have available to us are also problematic. The international law, when we start studying international law, I don't want to overgeneralize, but I think there's a certain sense of optimism that it gives us something. There's an oasis that we are getting towards. And then the more we start utilizing it, the more it turns out that actually there's a mirage there. We start using the law, and it starts to dissipate within our hands as we try to implement it, because there are inherently underlying gaps within the legal framework that we won't really recognize until we engage, until we start pushing through. And so I want to touch on some of those key obstacles that we've recognized in our engagement. One, on the criminal side, the issue of prosecutorial discretion. Robert, you mentioned the discretionary element within the particular German agency, not necessarily a criminal complaint, but still there's a discretionary element to that. And I think that issue of prosecutorial discretion, coupled with the civil counterpart of the doctrine of international comity, these are basically where politics and economics come into the law, or come into the pursuit of accountability. And leave open that possibility, regardless of how grave the crimes are, that the social and political and economic considerations allow a prosecutor to not move forward, or a judge to dismiss for various other reasons. And through this kind of engagement, I think we need to recognize international law has its limitations, and we need to push to bridge those gaps. At an international level, the work on the pursuit of a binding treaty that will apply international law to corporations and make corporations subjects of international law is a process that we have been engaged in for years, and it's been a process that's been ongoing for over 50 years. But until we establish very clearly this duty of care to corporations at an extraterritorial level, these obstacles are going to continue to remain, and we will continue to rely on the domestic mechanisms, despite those challenges as well with regard to prosecutorial discretion and international comedy. But I think in order to overcome those domestic challenges as well, we need more concrete steps at a domestic level. Let's not wait for the trickle-down effect of international law to the domestic and the domestication of international law. There is a process that can take place domestically, whether it's at the municipal level first, moving to the state level, that actually treats the Israeli settlement enterprise as Francesca's report notes, a joint criminal enterprise, and look at it from this lens that any activity associated with this enterprise is in violation of our law. And you can see the legislation developed in a very targeted way in jurisdictions that have the political will to do so, to move the needle. And it can go from the national, then have the international follow suit. We don't necessarily need the international to take the lead, especially when we see how states use international law or even regional regulations as excuses not to do anything, because the EU has all the information it needs to suspend the EU-Israel Association Agreement, but hiding behind the issue of consensus of all the member states, there's no action that is being taken. So are we going to continue to allow ourselves to be trapped in this system, which I sometimes cynically call the hamster wheel, because we exert ourselves, we put a lot of energy in moving it, but in reality, it gets us nowhere. So I think, if anything, we need to continue to find creative ways, but we also, I think, need to rethink how we see international law. Is it something, because maybe we haven't gotten to that oasis of what we thought we had after World War II, that now all the law is great, and now we just need to bring it down domestically. Actually, we haven't completed our mission to achieve the system of law internationally that we want to see, and we need to go back to the ground, have the people work from the ground up to reach that system. That's the only option to fill the gaps of the system as it is. Otherwise, it is tear down the system and rebuild it anew. And we know what kind of events take place to reach that level. So I think we have to take those lessons and try to move it forward. And I'm going to stop there because I know this has been a long session, and I hope that I know there'll be a phase or a second convening in maybe a month's time or so. Again, thank you very much for the opportunity, and I hope my contribution added some value to the discussion. Thank you.
Thank you, Wesam. It certainly did, and thank you for wrapping up the presentations in such a compelling way. I will now, as promised, I will now stop the recording. Actually, I will ask Tara, I guess, to stop the recording as co-organizer, and we can actually